think Titan will sort out Katerina, and anybody else that's having problems, hopefully just type a query to Titan and he'll sort you out. So the libel laws, the law of defamation, exists to protect individuals from unjustified attack. In other words, a false statement that injures their reputation and is published to a third party. Obviously, since we're in the business of publishing stories, publication is sort of axiomatic. We're in the business of passing information on to the third party. Individuals can be libelled, and so can a company, but not a dead person. The way the law protects individuals is that it allows somebody who thinks that they've been libelled to take civil action against the publisher, editor and writer involved. And if they're successful, they could be awarded a large sum of money by way of compensation. So every section of the paper or website, from stories and headlines to picture captions, news, features, sport, has the capacity to be defamatory. And obviously, in this world of bulletin boards and chat rooms, the whole question of libel is also raising a lot of interesting grey areas in relation to the web and the way that stories are handled on the internet. The journalist doesn't have to be the author of the offending statement, if that makes sense. In other words, if we report what somebody else says, that's not an excuse for us just to say, well, they said it, we didn't, we were just reporting accurately what they said. So if the town councillor says in an interview that the mayor's a swindler and a thief, the journalist which quotes him as saying so is in danger of being sued for libel if the statements are not true, because we're the one that's passing it on, we're the one that's publishing it. And for that reason, a reporter may have to omit parts of a speech or statement because it's libelous, even though the speaker themselves may not be aware of it. And we often get stories, I mean, this is especially true for feature writers, perhaps when you're doing an interview and somebody you're interviewing sort of says something rude about even a member of their family or a friend or their father or something, and it doesn't mean that it's safe for you to report it, certainly without checking it out. We'll talk a little bit more about libel in a moment, but by contrast, contempt of court isn't a civil matter, it's a criminal offence, and it relates to the publication of anything which interferes with the course of justice or prejudices a pending trial. So, I mean, obviously there are certain, we wouldn't set out to create a contempt of court, and you can imagine that as a working journalist you're not there to interfere with the jury or anything, but it's still possible that you could be writing about a pending case and find yourself in difficulties because of prejudicing that trial. The main trap for journalists is reporting matters after somebody's been arrested. Basically, when a crime's been committed, newspapers try to tell the fullest possible story, taking pictures of the scene, interviewing witnesses, getting descriptions of whoever was responsible and so on. The problem that we have to watch out for is, well, what happens with that story once somebody's been arrested and charged. Perhaps it's a good time to sort of mention the internet, and there's a widespread myth that somehow websites are above the law, and that's not the case, although new media in relative terms is in its infancy, and there are still quite a few grey areas which have yet to be tested in court. Anyone working on the internet should be aware that the legal restrictions which apply to newspapers and magazines and broadcasters are just as important for those who are working online. It's basically irrespective of the means by which the information is published. I think the confusing thing about the internet is that obviously a lot is said by individuals who may break the law but get away with it. That makes it tempting to think that you're free to say just about anything you want. But of course the difference is that as professional writers, freelancers and so on, you tend to be working for customers who are major publishers in their own right, or major corporations making a fair bit of money, and they are the sort of people that somebody's going to target if they're going to sue somebody for libel. There's probably no point trying to sue a football fan who's writing a blog from an attic in Cardiff attacking the manager of the local club, because they won't have very much money to pay you. But if the local football reporter who's working for a sort of major publisher, well, obviously the big newspaper publishers and broadcasters in this country do make a lot of money, and for them it's a bit of a challenge that they're still struggling with, the idea that especially now that there's more and more involvement of readers through newsgroup postings, bulletin boards, chat rooms, discussion forums, and of course increasingly people are uploading things from mobile phones and their own pictures and so on, then that poses ever more challenges, I think, for existing publishers as to how to stay at the cutting edge of interactive publishing without actually finding themselves legal difficulties. So if we go back to just a moment to ask what's meant by a free press and freedom of speech, and what rights do we have, what restrictions apply. Press freedom is regarded as being a fundamental feature of a parliamentary democracy like ours, and Britain's got a long tradition of a free press, where journalists are encouraged and enabled to keep the public informed, to comment freely, and especially to expose wrongdoing. Judges and government ministers have repeatedly reiterated their support for that principle, as have the European courts. But at the same time, they've also sought to balance that freedom against the rights of individual citizens of the type that we've just been talking about: the right to a fair trial, the right to privacy, and the right to protection against having your good name destroyed sort of maliciously. So Britain's got no codified constitution, as you know. It has a fairly complex constitution in the sense that it's found in many different places. And traditionally, citizens here are said to have residual rights, in the sense that we can do anything that's not specifically forbidden by law. From a journalist point of view, we're largely in the same position as ordinary citizens, that we don't have any sort of significant rights beyond those of the ordinary man in the street, although there are certain privileges and facilities extended to us by people or organisations to make it easier for us to do our jobs, so that we have, for example, perhaps there's a press bench or communication facilities and that kind. Sir John Donaldson's judgment in the Spycatcher case in the Court of Appeal in 1988 perhaps sort of best sums up the situation, when he described the media as the eyes and ears of the general public. And another judge re-emphasised that in 2000, Lord Bingham, when he said, the proper functioning of a modern participatory democracy requires that the media be free, active, professional and inquiring. You'll be aware that